I'll begin with a very unique situation that arose a couple of months ago, and then it was repeated by another unique situation. Our firm was contacted by someone who was at the border. So this is a client who had landed in Canada after being approved on the Startup Business Class program by the IRCC. They had a confirmation of permanent residence in their hand. They had their passports that were stamped by the visa post abroad, and they were advised by their consultants that this is merely a rubber stamping process, and all you have to do is just present these documents at the border, and you will become permanent residents. Mind you, this is after waiting probably over 3.5, 4 years of processing under the program. So they land in Canada, they go to secondary of the CBSA to say that they are landing as permanent residents. And the CBSA officer raises some concerns. They ask them questions with respect to their business. They ask them questions with respect to the progress that they've made on their business. They ask them whether they have any bank account that's functioning currently in Canada. They ask them about, tax records. They said, have you been working in Canada? Please provide tax records. They asked them about other team members who've been working on the business, about their families, or what part of Canada they're staying in, and a number of different queries to establish whether the business is that they intend to establish is real. And they also wanted to check whether the business is established in Canada already. And so they reached out to us from the airport after having been grilled by the CBSA for between 3 to 4 hours. And I rushed to the airport. Noman and I had a very interesting conversation with the client, and I rushed to the airport the very next day because the client was called back again. And we stayed with the client for over 8 hours, in which the officer had questions over questions with respect to a number of different aspects about the business. What we've come to realize now is that the client had made certain observations and made certain statements with respect to the progress of the business, and the CBSA was evaluating whether the information provided by the client to IRCC was correct information or not. CBSA was trying to evaluate whether the business was artificial, in the sense that whether the client had just created the business to avail permanent residency under the Startup Business Class program. And these issues are arising, and they're very real, because just last month, we faced another very similar issue with another client who was landing in Canada after being granted permanent residency by IRCC, and a similar issue arose. For this client, because they had contacted us at a stage where they were interviewed for one day, and the next day the officer had requested for certain information, we equipped the client with a comprehensive port of entry letter in which we explained how all the criteria of the Startup Business Class are met. We also gave answers to all the questions that were raised by the officer in a written email, and we provided documentary evidence, and we were there at the airport to represent the client for any other issues that the officer may have. This time, this client was landed as a permanent resident because there was clarity of thought with respect to what questions were asked and what answers were needed to be given. The earlier client, unfortunately, had to leave Canada because of certain personal circumstances, and they had to withdraw their entry. But that case too, we are currently litigating before the federal court. In essence, what I'm trying to say is that even if your application for permanent residence is approved under the Startup Business Class program, the process of landing is not merely a rubber stamping process. Even there, you have to be fully equipped. You have to be ready to answer any questions that are raised by the CBSA officer at the port of entry while they are landing you as permanent residents. And if at any point the officer frames an opinion that the answers that you are giving are fraudulent, fictitious, and the information that you've provided to IRCC is misrepresentation, then you may be stopped from landing and another process may be started against you.
Great. Thanks,
Yeah.
Pushkar. I think the point there is we can see that there is enhanced integrity, and your process is not complete until you actually have your PR visa completed, and it's really critical that you prepare in advance. When you're in front of an officer and you're being admitted, you don't have counsel beside you, so you do need to have discussions. What we typically do is have a landing process. We make sure clients are prepared for all the different questions that they can be asked. You should have materials there that you can present, and you should appreciate that the information you provide can be used in making a determination against yourself. That's why it's really important that you do have good legal advice, because these processes are being scrutinized. Keep in mind, as I mentioned earlier, one of the big concerns was about artificial transactions. And so when cases were filed some time ago, officers at that time were approving cases without as much scrutiny as we see today. And so they can definitely take a second look, and it's important to be very careful.